summarized in the MOU that Sita has signed with National Treasury, and that MOU, which also includes the role of the Department of Communications and Technologies, as well as the role of Dpsa. With permission, Chair, I won't go slide by slide because it's exactly as it was also projected by National Treasury. So Sita, on the next slide, we then provide what we call it hosting services. When the system is implemented, we ensure that it is hosted in a secured facility within Sita to ensure that we protect data sovereignty and all the related things. But the second one, which is the critical one, we then assist the department in terms of procurement of the services, including procuring the implementation partner. So Sita is not the implementation partner, but procuring the services of the implementation partner, as well as when the system is then developed and is implemented, then Sita supports and maintains that system, provides what we call it your center of excellence, which means for any problems that users of the system has, there is technical people and functional application specialists that will then be able to assist the users of the system to be able to use the system. And then lastly, as we are looking into the implementation, we do a technical readiness assessment. If you are going to pilot a module within Dpsa, we then assist you to do the technical readiness assessment, whether are you able to do that pilot that you intend to do. If not, what are the things that need to be done to ensure that the department is ready for whatever module or for whatever plan that you have within the implementation. So we all provide all of those technical assessments. That's the role of Sita. As per the MOU that has been signed, which I know I signed when I was MD 3 years ago. And I also can confirm that has also been signed by the DG of National Treasury. As I remember, those were the only two that signed that MOU. So that's then the role overall. So if we then continue to the next slide, as then explained in the RFI that was then published by National Treasury recently. So that RFI looked roughly to say the technology has now moved to cloud, meaning when we procured the solution, it was going to be fully implemented running on servers that National Treasury and government owns, meaning it's running on our own infrastructure, not on cloud. But now, since technology has moved to the cloud version, we then have to do the risk assessment, the technical review, especially as we'll then understand there were the Dpsa guidelines or cloud directive that talk primarily around data sovereignty, data risk, because if you are now talking cloud, how do we then ensure that government data is protected? Because you're going to have people's ID numbers, salaries, everything that runs within that. And I want to explain it just simpler so that you understand what it means. Because now you're talking about data of every employee of the country. And everyone is a public servant. And that data has to be secured. So when we then look at that in terms of the cloud directive that the Dpsa has issued, so we looked into those things. And as part of that is to say, how do we assist National Treasury as we negotiate with the OEM, in this instance, Oracle, to ensure that the data of South Africa is resident within the country. And not only sovereignty, but also your data security, so that we can ensure that that data can be used for any other purposes. So that's then the technical review that we have done. As part of that risk assessment, we have then given them views in terms of what is it that can be done, what can be modernized. So also on the commercial, so commercials basically say when we bought this application before, we were going to own the licenses and everything was going to be running with us. Now you're taking us to cloud. So if we spend R1 billion purchasing the initial one, where we're now going to own the licenses, and we are now moving us into a cloud option of the solution. We want to ensure that we still get the value equivalent to the initial investment of the licenses. So we also gave them a view on that in terms of the technical assessment we have done to ensure that there is recognition of the investment that has been made already. So you don't start moving into cloud and you are charged exactly as if you didn't spend money into that. So that report also has been given to give a view for that, as well as then alignment and assessment and alignment of that which needs to be done with the original 2013 business case around the implementation, still ensure that it's cost, so it's commercial off the shelf, meaning you don't do too many modernization of the solutions, because the more you do modernization, then the cost more than double. So how do we then ensure that as you go to cloud, you keep it as simple as possible? Accounts payable is accounts payable. You don't have to spend and modify it the way that you like, because you understand those things have a practical financial and support implication. So in essence, that's then the review that the DG for Treasury also mentioned in terms of the RFI that was done, and all of the outcome of that has been provided to National Treasury, and National Treasury has reviewed that, and in this state then using that to make the decision about the implementation as explained in the implementation plan. So moving then to the next slide in terms of the role of Sita. I will skip the tasking, which basically saying we were asked then by National Treasury to conduct that process. So the review approach, I've summarized it, has been done. We're doing it jointly with the technical team that sits within National Treasury, and National Treasury is implementing the suggestions that we have recommended to them. We have now also moved beyond that to say now that there is an indication that we will move into the cloud variant. We are also then talking about the anticipated role, or what's then the future role of Sita. So all of those roles that is explained on slide 10 is exactly as was explained by National Treasury. So I will not repeat it. We provide technical support, meaning we provide IT technical people that help them in reviewing that which they need to do. We give comments, we assist them on implementation of that which they need to do, as well as any technical management, which means in Mr. Nzangani's unit, we have more than 100 people, technical people that are assigned and dedicated to support this rollout to ensure that it happens as we intend to do. And on your next slide, Simon. So roughly then within that, we're then saying what we call it the center of excellence, or the technical schemes to support the pilot that National Treasury has done. We have dedicated those resources to ensure that they are available to assist the department. I explain it this way so that we are clearer on the roles of each and every entity. So in terms of the Sita Act, our role is not to implement, but our role is to be the support partner to the department that is the role of implementation of this. And in this instance, the chair, it is National Treasury, and we will explain any other questions that have in terms of the RFI review that we have done, or the procurement processes that we have assisted them to get where they are, or the readiness assessment that we have done in line with what Ms. Digeleti has raised about the implementation approach. So I've also assisted them with that to say, indeed, these are quick wins. Your e-recruitments, these are things you can implement now. Your procurement module, these are things you can implement them now, because it will be easier to implement them, but also these are functionalities that are required by government. But lastly, also, we see from Sita that there are departments that are trying to procure similar solutions. So it will be better you quickly implement this so that other departments don't go and buy similar solutions around this. So that assessment is also have been done and has been shared with them, and it is in line with their implementation approach. I will stop here, Chair, and we will answer any questions. Thank you very much.
And thank you very much. Thank you very much, Sita, for the presentation. DG Dpsa, you have anything to?
Thank you, Chairperson, and good morning to the honorable members, the Deputy Minister, DG Treasury, Advocate Motili, and colleagues. I just have a few comments, Chair. Firstly, just to confirm that we have worked jointly with Treasury on the presentation that they've made. So we've made our inputs as a Dpsa. And you touched earlier on the fact that the Dpsa was withdrawn from the process by the former Minister, Minister Lotto. Indeed, that is the case. When Minister Lotto started Dpsa, that would have been in 2021. She did issue a letter to Treasury withdrawing us out of the process as Dpsa. So we're inactive in terms of the process after we received that letter. But then she then left and Minister Macy joined as an acting minister, and Minister Macy brought us back into the process as Dpsa. So we're fully part of the process currently, and we're participating. Mr. Case highlighted that it's only them and Treasury who had signed an MOU, which
reports for purposes of ensuring that the department is aware of the ongoing investigation and the outcomes that we reach, so that that can support the invoices that we issue. Then the department can see what we have reached as outcomes, so that they can our invoice. Now, based on all the outcomes and the investigation, the law requires that at the end of the investigation, we produce the final report. Or as the president may deem appropriate, he may ask for interim reports. So the report of the whole investigation by law goes to the president and no one else. So we've received from time to time queries from departments saying you're investigating into our departments, but we don't get the reports. That's the nature of the provisions of the law. But we do say they are welcome to request the report from the president. In any event, the president has taken that the reports that are now submitted to him, he releases them to his executive authorities of the state institutions and to the accounting officers or accounting authorities, as the case may be. So that's really the reporting. So to date, we see that we're still working on. So we haven't seen the report yet. So, but there's been those kinds of referrals that have been made. Those could have been understood as reports, which is fine in that context. I thought I would just clarify that as we move on. The next slide, please. We now move on to the introduction of the investigation. And we'll really just outline as we deal with the background to the investigation, which Ms. Jose will take from there. This investigation was conducted, as I said. We received the whistleblower report in terms of the corruption that could have set the procurement process, and we went on to assess and prepare the proclamation that was signed. Proclamation R4 of 2020. In the process, it was also amended by Proclamation R40 of 2020. And the rationale for the amendment is that because we work within a specified scope of the proclamation, if we get evidence that requires us to include other aspects, we do not just do that. We then seek the proclamation to be amended, because that's a very important legal process. So this proclamation mandated SIU to investigate certain allegations of impropriety in connection with the affairs of the National Treasury. And this pertained to the procurement of or contracting of the integrated financial management system by or on behalf of the National Treasury, and payments made in respect thereof. As we have indicated, that the proclamation was amended in the process, amongst others, to ensure that related activities relating to Sita and Dpsa are appropriately included in the process, amongst others. So that's the introduction. I'm going to now hand over to the lead investigator, Ms. Naomi Jose, who will take the committee through now the actual investigation that they have conducted, and I'll come in if necessary at the end of the presentation. Thank you very much.
Chairperson, Minister, DG, Treasury, and Dpsa, and other colleagues. Advocate Mutibi has indicated that we were mandated by Proclamation 4 as amended by Proclamation R4, as amended by R40, to investigate this matter. With regards to the background to the information, the SIU had received a whistleblower's report, and this alleged that there was corruption and irregularities with regards to the procurement of the IFMS system, which was awarded to Oracle. So the allegations were that the procurement process and the award for the Tier 1 commercial off-the-shelf enterprise resource planning solution, which I'll refer to as the COTS ERP, was irregular, that there was performance or no performance by the service provider, that Treasury didn't receive value for money, and that a corrupt senior official at Treasury was involved in the award of the Oracle contract. So in 2005, Cabinet had approved a hybrid solution for the IFMS. In 2013, the solution was changed from the hybrid architecture to COTS ERP. In November 2013, Cabinet had mandated the procurement of the COTS ERP, and in January 2014, the IFMS Steering Committee had approved that the procurement of the COTS ERP would be done via Sita. The IFMS system, sorry, is there a reason it's echoing? Can I continue? Okay. The IFMS system was required to deal with 4 legacy systems. This would be Transversal, which dealt with assets, Persal, which is the human resource module, the Locus, which dealt with procurement, and Vulindlela, which is business intelligence. Now, the IFMS project was driven and managed jointly by Treasury, Dpsa, and Sita. DPS's role was in respect of the HRM module and to ensure that the relevant public service business requirements were catered for. The first COTS ERP tender was advertised in March 2014. However, it was cancelled due to an objection from a bidder. A new COTS ERP was advertised on 28th November 2014 and it closed on 30th January 2015. If I can go into our focus areas, as the SIU, what the areas we focused on was to investigate the procurement of and the contracting for the IFMS on behalf of Treasury and all payments made in respect thereof, to determine whether a proper procurement process was followed, whether there was malperformance or actually any performance by Oracle, determine if Treasury received value for money and if any losses were incurred, to conduct a corruption investigation, and this would include profiling and lifestyle audits of the service providers and officials. We don't need to go through the objectives. With regards to the findings, the first one is the conflict of interest. Now, here the SIU established that prior to awarding the RFP for the COTS ERP, Oracle was actually in contact with senior officials at Sita and National Treasury. So Oracle received information about the IFMS project, about the tender, the financial implications, competitors' information. And this information, which was given by the senior official, was obviously to the benefit of Oracle, and it gave them a competitive advantage over their competitors. The leaking of information impacted on the integrity of the tender process, which would include the fairness and competitiveness. So the SIU reviewed numerous emails which were exchanged between members of Oracle as well as this Treasury official, and it was very clear that the evidence which was given was acquired during the course of the official's duties at Treasury. We also emphasized that the information was not available to other bidders, neither was it in the public domain at the time. With regards to the SEM process, here the SIU reviewed all the tender documentation that was made available to it, and we detected various areas of non-compliance. So we'll first go through the non-compliance, and which obviously impacts on our findings. So the business case from Treasury, it was signed by the accounting officer. However, it was signed by the accountant general, but it wasn't signed by the accounting officer. And this is a violation of Sita regulations, which clearly states that the business case must be approved and signed by the accounting officer. The request for the proposal was specifically for the procurement of software licenses, maintenance support, and consultation services. We'd like to emphasize that it didn't implementation and implementation services. This will become evident a bit later on. The position of the accounting officer of Treasury was obtained before the bid evaluation committee was established. The BEC also not established before the bid was published, which is required by Sita's SCM policy. On the 5th of December 2014, there was a compulsory briefing session at the Sita auditorium, which determined that from the minutes of the meeting that it was attended by Dpsa and Sita, whereas Treasury, who was the designated department, did not attend. In terms of the sourcing manual, all stakeholders had to be present at the compulsory briefing session. So on the 6th of February 2015, Sita's SCM issued letters to Oracle and SAP, who were the two final bidders, requesting them to confirm that the proposed solution complied with the minimum interoperability standards certification, which we'll refer to as the MEOS. Now, it's important to note that the MEOS wasn't included in the bid documents. In fact, it was only submitted to Oracle and SAP after the closing of the tender, and it's a statutory requirement that bidders have to comply with MEOS standards when they're offering an IT solution. On 11th to 13th February 2015, the Price Evaluation Committee evaluated prices which were submitted by Oracle and SAP. The PEC signed off on this, and the following prices were submitted: approximately 670 million from Oracle and 100 million from SAP. Sorry, 100 million. Sorry, 1 billion. The PEC went with the Oracle price. Oracle didn't declare in their SPD forms that they had previously provided services to the state. During the course of the SIU investigation, we established that in August 2014, Oracle had actually signed a framework agreement with Sita, but this wasn't disclosed. Oracle also didn't declare in their SPD forms that they had a direct interest, in that they failed to disclose their relationship with the senior Treasury and Sita officials. The Treasury and Oracle, the Treasury and Oracle directors also had a working relationship at the Gauteng Shared Service. Oracle failed to complete the mandatory requirement, Section 12, of the general condition of bid in their submission. Due to the fact that they didn't complete it, the bid should have been regarded as incomplete, and they should have been disqualified. They also initially failed to accept Section 12.12 of the mandatory requirements of the general conditions of contracts. Now, Section 12.12 relates to the fact that the bidders are not allowed to amend the proposal with their own conditions. Given the fact that Oracle did this, they also should have been disqualified. On the 9th of July 2015, Treasury issued a provisional award to Oracle on condition that the final award would be subjected to the successful negotiation between Treasury and Oracle, which would result in an SLA between the parties. Now, during contract negotiations, Oracle's price increased by 12.8% through a variation process. It increased as a result of Treasury procuring additional product license, which fell outside the scope of the cost procurement. So the price of Oracle increased by 85 million. So it increased from 670 million to 756 million. In terms of the Sita SCM policy, Sita SEM may negotiate the final terms of a contract with bidders identified through a competitive bidding process as the preferred bidders, provided that such negotiation does not allow any preferred bidder an unfair opportunity. In this case, it did, because it allowed Oracle to amend the bid after the award, is not to the detriment of the any other bidder. In this case, it clearly was. It does not lead to a higher price than the bid as submitted. 15% variation may be allowed. Now, even though it was only a 12.8 variation, it must be noted that the products which were acquired fell outside the scope of the bid. The procurement plan was not issued and signed off within 10 days of the business case being issued. The business case was signed in November 2014, and the procurement plan was only issued in January 2015. The available evidence also indicates that the recommendation issued by Sita for appointing Oracle was not approved by the Oracle board. In this regard, we came across a letter which purported to indicate that the board's approval had been obtained. However, when we interviewed the official at Sita, who was supposed to have written this letter, he indicated that he hadn't written the letter. We also interviewed an individual in the office of the Sita company secretary, and they couldn't locate any board resolution, and they also went through the minutes of meetings, and there was no board resolution. SAT, who was the other bidder, the attorneys wrote to Treasury because they considered the award to Oracle to be irregular. They noted from various industry sources that Oracle had been allowed to amend their bid regarding the proposed software licenses and the pricing after the closing date of the bid submissions. However, the Office of the State Attorney did submit a letter indicating that Treasury felt that the contract to Oracle was not irregular. A master agreement was concluded for a 5-year period between Treasury and Oracle for the purchase of licenses, support and maintenance, as well as consultation services. Now, on the 13th November 2015, a memo was compiled by a senior official requesting that they include an addendum to the master agreement with Oracle. The memo requested approval to use the consultation services which were in the agreement, and it was actually going to be used for pre-implementation services, which were the architecture and blueprint to guide the implementation of the IFMS. This was approved with a budget of 26.2 million, although the actual spend was 24.8. So it must be noted that this was not part of the scope of the master agreement. Also, Treasury claimed these services, the pre-implementation services, under the auspices of consultation costs, which was actually a misrepresentation. As we have indicated before, there was no provision for pre-implementation or implementation services during the procurement process. On the 3rd of July 2018, Treasury had tasked Sita to assist them in procuring accredited Oracle service providers to assist in the implementation of the IFMS program. So in December 2018, the establishment of a panel of Oracle specialized partners for the implementation of the IFMS was advertised to the market by Sita. Evaluations were conducted, and the successful bidders were recommended to Treasury for appointment. Treasury then did their own due diligence. And on the 27th of November 2019, a recommendation was made by Sita to Treasury to appoint these accredited panel of service providers for a period of 3 years. Sita had identified 58 expert providers. Now, on the 3rd of March 2021, a senior Treasury official had made a presentation at the IFMS Steering Committee regarding implementation of a so-called new hybrid approach. The SIU reviewed the presentation, and we noted that it actually didn't address the change in the implementation of the product, because Oracle was still going to be used to assist in the implementation of IFMS. It also didn't address change in any of the implementation sites. It was already decided in 2017 that National Treasury and Dpsa it would be rolled out, it would be the pilot projects to roll out IFMS in the Eastern Cape and the Western Cape. Neither did it address the change in the implementation architecture and methodology, as the aim was still to roll it out to national and provincial departments. The official who made the presentation actually misled the IFMS Steering Committee in that she advised that a resolution had been taken by Treasury's BAC that it would not recommend the appointment of the implementers, and that Treasury's accounting officer would not approve this appointment. This was misleading because the chairperson of the BAC informed the SIU that no such resolution had been taken, and it had in fact resolved that Sita would recommend the implementers for appointment. During this presentation, the official also requested that the bid for the implementators be cancelled and that a new implementation approach be adopted. Now, on the 15th of March, the official did issue a cancellation letter to Sita. In the letter, it was stated that in order to address the risks faced by the IFMS program, the implementation approach had been reviewed, updated, and approved. It also stated that the adoption of this updated implementation necessitated the cancellation of this RFP as no longer aligned with the program. However, we established that the change in implementation approach didn't actually necessitate the cancellation of this bid, as it didn't impact on the scope or the relevance of the IFMS program. So the cancellation of the RFB was in contravention with section 13 of the preferential procurement regulations. The cancellation did not comply with section 13 in that it's 13.1 states an organ of the state may, before the award of a tender, cancel a tender if, due to changed circumstances, there is no longer a need for the services or goods specified. In this case, there was still a need for the IFMS program. Funds are no longer available to cover the total envisaged expenditure. There were no budget constraints. No acceptable tender is received. Sita had identified 58 service providers. There is a material irregularity in the tender process. In this instance, there wasn't. Treasury had purchased 18.8 million licenses from Oracle, and to date can only account for use in one department, being the Gauteng Department of Infrastructure and Development. The available evidence which was presented to the SIU indicates that Treasury has as yet not implemented the IFMS program. This has been referred to earlier by other parties. The Auditor General made findings that the IFMS project was fruitless and wasteful expenditure. The Auditor General had in fact obtained 2 legal opinions, and in which Senior Counsel concurred that in their opinion the expenditure incurred by Treasury for the IFMS software was fruitless and wasteful expenditure due to the fact that no value was derived. The Council's view was that the IFMS project had all the hallmarks of fruitless and wasteful expenditure for the following reasons. While the Oracle contract is for a period of 5 years, terminating May 2021, no progress has been made in terms of the contract. No value has been received in terms of the contract, and the contemplated implementation period runs outside the 5-year period. On the 21st April 2021, a senior Treasury official had sent an email to Sita to follow up on the cancellation of the panel of implementers. So the email stated that identified a risk that should we not deliver on time, including accelerated implementations, we will incur wasteful expenditure on the 69 million. So Treasury was aware of that. During our investigation, we established that the reason for the delays in implementation was caused by the unsuccessful procurement of a panel of for the implementation services. Treasury had cancelled these procurement processes on more than one occasion, and as a result of pure procurement decisions taken by Treasury, this resulted in the fruitless and wasteful annual expenditure of 68 million. Now, if Treasury had approved the appointment of the panel of experts, which was recommended by Sita in November 2019, chances are that the IFMS wouldn't have incurred this fruitless and wasteful expenditure. If they had appointed the panel of implementers in 2019, it is possible that the IFMS would be at a very advanced stage or even rolled out nationally and provincially. After being advised by the AG that continuous payment of the annual fee of 68 million was fruitless and wasteful, Treasury continued to make this payment. The SIU is also of the view that annual payment of 68 million in respect of the maintenance and licenses is fruitless and wasteful expenditure. During May 2016 to the 30th of June 2021, Treasury paid a total of 822 million for license fees, support, maintenance, as well as pre-implementation services. The pre-implementation services came under the consultation costs. Now, before the master agreement with Oracle could expire on the 29th of April, on the 8th of February 2021, a senior Treasury official requested that a director in the IFMS program compile a memorandum for the approval to extend the current master agreement for 5 years. That would be from April 2021 to April 2026. The extension of the Oracle contract was approved for a period of 5 years. The available evidence indicates there's no written contract in place between Oracle and Treasury for this extension.
Are you going down? Oh.
Earlier on, we mentioned that one of the allegations from the whistleblower was that a Treasury official had motivated and supported the decision to award Phase 2 of IFMS to Oracle. We established that the identified official actually wasn't involved in the procurement or negotiations with Oracle. We conducted a lifestyle audit and there were no adverse findings, so it was established that the allegation was unfounded. With regards to outcomes, 2 disciplinary referrals have been issued. We actually would have issued an additional 4 more, but 3 officials had resigned and 1 official is deceased. 1 blacklisting referral has been issued. 5 criminal matters have been referred to the NPA, which include 2 former DGs of Treasury. With regards to civil, the SIU has briefed the Office of the State Attorney, who has been requested to brief Council to consider the review and setting aside of the contract relating to the appointment of Oracle at a contract value of 822 and to recover the just and equitable amount. This process is still ongoing. The presidential report has been compiled and it's currently going through the SIU review protocols. The SIU has identified certain systemic weaknesses and we've drafted a few recommendations to mitigate it. I won't go through all the systemic weaknesses, but it's important, for example, to perform proper feasibility studies for new projects, to adhere to legislation and policies. Things like the business case should be approved by the accounting officer. They also need measures in place to prevent the leakage of information in respect of bids, as was done between the official and Oracle, to ensure that the BC members are appointed before the procurement process and that they are appointed by the accounting officer, and to verify the final bid documentations to avoid scope creeping, not using say, for example, consultation costs as for, to cover up for pre-implementation, and basically also to keep a proper record of all documentation. Thank you, Chair.
Thank you very much, Advocate.
Thank you, Honorable Chair and Honorable Members. That's the presentation. And again, just to restate on the outcomes that I mentioned when we started the presentation. The disciplinary referrals. Can you please just reflect slide 35? The disciplinary referrals that we mentioned there, those are the ones that we would have prepared a report around the disciplinary referrals and sent to the National Treasury. So that could probably be sort of perceived as a report as well. And as my colleague indicates, evidence points to other officials who have since left the department. However, even though they've left, as part of our process is that if we identify that they were part of any prejudice or loss caused to the department, when we go to the civil part, which is bullet point number 4, the legal team will assess whether to cite them as respondents in the legal process as well. It is important to note that. And then there's the blacklisting part, which is bullet point number 2. And of course, that has got its own process in terms of the Promotion of Administrative Justice Act. It follows its own process and they will be allowed there. And then, of course, the criminal referrals based on the irregularities that we have found. I thought I would just clarify that part. Honorable Chair, that is the SIU presentation. Thank you very much. We'll take questions if there are any.
Thank you very much, Advocate Mutiba and your team. Thanks to the TM Treasury Treasury presentation. Thanks to Sita for their presentation, and thanks to the DG of the Public Service Administration for comments in owning up into the involvement in the project. Now, colleagues, who have been listening to the reports, fortunately, the reports have been with us for a period, and the pointers are: one, our involvement has been triggered by the fact that the Auditor General has made a finding which seemingly follows the trend
where the internal audit investigation and in forensic investigations took place within Treasury itself for time. July 2015, National Treasury Audit Committee requested Internal Audit Unit to perform a review of the IFMS payments for the year 2014-2015. The internal audit investigation revealed a total of 54 findings. Those 54 findings, 49 are referred as very catastrophic out of the total in terms of relating to risk rating, and had 5 which had high risk ratings. The investigation indicated weaknesses in internal controls to mitigate the risks and weak monitoring systems. The internal audit investigations indicated that the internal controls could not be relied upon. The audit committee presented the report to the then accounting officer. In March 2016, and formally requested an independent forensic investigation. You see, those are the steps that have been taken through this process. Deloitte was awarded the tender on the 1st of October 2016. Deloitte found no wrongdoing by National Treasury's officials working on the IFMS project. The only conclusion they made was that the lack of human resources was partly to blame for the adverse findings of the internal audit investigations. The forensic report by Deloitte was rejected by the audit committee. A new tender was issued for the forensic investigations, and Nexus was awarded the contract on the 1st of February 2018. Nexus completed the investigation, and the report was submitted to National Treasury on the 28th of August 2018. The report highlighted the following findings. 1, irregular expenditure of 273 million rand, unauthorized expenditure of 17.8 million rand, non-compliance with the SCM processes, poor documentation of crucial contract information, lack of project management controls, payment of license fees to licensees not being used, fruitless and wasteful expenditure, weakness in internal controls, lack of formal business case for the IFMS project, insufficient resources to fully implement the IFMS project. So in my language, we would say Dolofia list hot to so it in sequence highlights a number of processes which are both internal. Now the SIU is coming up with a process which is external. Sita is presenting to us its own role in as far as advising, certifying the process. Treasury has told in terms of implementation of the process. The Dpsa former minister citing their withdrawal, noting a number of things in her letter
of withdrawal. Now the resuscitation of the project. So all those kinds of things bundle up what we're dealing with and what has pulled us into this kind of a scenario. The Deputy Minister.
Thanks, Chair. And then thanks to all the presentations, starting from National Treasury to SIU. And Chair and honorable members, I have no competency to challenge any of the reports, including the last one presented by the ICU. SIU, sorry. Did I say what? ICU? Yeah, sorry, my apologies, Chair.
My mind is correct.
I've been to hospitals in the recent past, so I spent a lot of time in the hospital in the last few days. So
project is nice.
SIU, yeah. So I have no really competence and capacity to challenge the content, and I do think that the SIU, they've done and they're doing their job without fear or favor, and we must really appreciate that. However, and I'll need guidance from yourself in this regard, which is that the report by SIU indicates that it's not final. It is still going through SIU's internal review protocols. And I'm sure it still has to be presented to the president. And I'm not certain if also the former DGs have been engaged on the findings. So I'll need your guidance here on how do we deal with reports that are incomplete? How do we respond to them? And without coming across like we want to hide anything, but we'll need your guidance in that regard. Is this report for noting? And whether in our deliberations and our responses, as people who've been asked to come and account here, how should we handle a report which is still in the making? Without saying it would, we don't know how finally the report will look like, but I just need your guidance in that regard.
Thank you very much, DM. Before I throw this to the members to comment, I'll make my own ruling after. If there's any comment from the members, you want to say anything, Advocate? Okay.
Honorable Chair, thanks. This may just assist the Honorable Chair and Honorable members as they consider the responses of questions. And I did indicate that these issues about the reports may probably create a sort of a misunderstanding. The slide on the outcomes that I spent a few minutes on. As we investigate and we then come to a conclusion, firstly that the contracting or procurement process was irregular, and you can see there that we are already starting a process of civil litigation to set the contract aside. So that outcome is completed. So for purposes of the investigation, that is complete. And that is why we are taking an action now, even before we submit the report to the president. So that part is complete, and we are pursuing civil litigation. So, of course, and I had the DG National Treasury earlier saying, there's areas where they sort of have challenges, and we'll obviously welcome the interaction. But that part is complete, and we are prepared to just engage as we prepare to go to this special tribunal. With regard to the outcomes on disciplinary action, again, is on the same basis that we have gathered evidence pointing to the misconduct of officials, and that part is complete. And action is required on that part. It's complete even before we produce the final report to the president. Now, similar to the others, like referrals for blacklisting and referrals for to NPA, it does mean that we have picked up evidence in our view that points to criminal action, and that's why we have referred. So all the outcomes and the referrals that you could call referral reports are final in their own nature. They are final in their own nature, and in fact, the High Court in the recent past actually was dealing with one of the referrals, and the question was whether in the nature of the referral could it be challenged or not, and the answer given by the High Court is that yes, that referral as it is challengeable even before we produce the final report to the president. So I really want to clarify this such that it's clear that the outcomes for action do not necessarily have to wait until the final report of the president. So as we present today, we're of course presenting the status of the investigation and where we are and the outcomes that we have reached. So for purposes of today, we are indicating where we are and certain outcomes which are finalized, and that we are really just preparing the final report, which will include all of these outcomes and so on for purposes of the president. Thank you.
Thank you very much, Advocate. Colleagues, do you have any comments before I deal with the matter? Honorable Liz.
Thank you, Mr. Chairman, and good morning to everyone, and congratulations, Duncan, on your appointment. Not a good start this morning, but we'll be monitoring you. Pass the buck. Mr. Chairman, I think that Advocate Matibi has indeed said almost exactly what I was going to say, which but just let me add a little to that, in the sense that how National Treasury deal with the reports, DM, is really up to you. I heard Duncan saying he had, you guys have approached council and so on, and I think it would be dangerous for us as a committee to give you advice of how to deal with that report. So, Mr. Chairman, that would be my, without now going into the general question session, my view about the DM's request from us. Thank you very much.
Honorable Makamba.
Thank you very much, Chairperson, and good morning to all. My question is on the issue of the SIU report, where it also implicates the Treasury Department in terms of their negligence in carrying the cost, which is the fruitless expenditure. So what I want to know is the Treasury Department going to take full responsibility and accountability?
You've written down the question.
Yes, I have.
Written down the question. Just wait there. Yeah, I'll give you
okay.
a time to ask the question. what the DM has dealt with is a crucial question as to how do we take the report of the SIU. If you take note of our the actual intention is to get the briefing on progress made by SIU on matters that relate to IFMS. And that progress report has been received from us, which relate to the steps that have been taken into that kind of a process. Honorable Yes is 100% correct that we are a receptive party to such a progress, and the parties involved in terms of the primary matters raised, the contextual scenarios and all their own findings is in the parties' interests to deal with in any other way they feel. Ours is to receive and appreciate the report as advised by the investigating authority on such. And that's why we don't want to devil that environment or the actual context by getting involved into the investigation. It's only receiving that form. And our questions are questions that relate to clarity on such issues, if need be, to unravel certain matters which need some form of a follow-on on such substantive matters. So your question, if you want it to be answered from our side, that what the advocate has said, added by what Honorable Lisa said, to us, we are glad that we have received that kind of a progress in as far as IFMS scenario is concerned. And it's up to the department to deal with it on their own time between the two parties. DM?
Thanks for that clarity. And I think Advocate Mutivi was also useful in providing clarity, because my concern stemmed from where they say that the report is still undergoing internal review processes. So I was like, for lack of better word, confused that on one hand, you have a report that you are presenting, but you still want to subject it in your internal review processes. So I feel like they're presenting an incomplete report, where they should have said, look, give us a chance to exhaust all the internal review protocols within the SIU. I think that's where my concern and confusion came from, but I'm clarified. Thank you.
No, thanks, justifiably so. That the scales were directing into the level of saying even themselves, they would want it to get into some tests somewhere. So it's an understandable interjection as far as your thoughts, but maybe that clarity has been provided. Well and welcome. Thank you very much. Colleagues, those are the reports. So already there's a question which has been posed by Ms. Makamba, so to provide you that opportunity and then come back to you, Honorable Lias, so that we can move towards that direction going down. Honorable Makamba.
The first question I've already mentioned to the department, if they are taking full responsibility and accountability of the fruitless expenditure that has been incurred because of this system that was never implemented in the first place. And my second question is on the issue of the turnaround times. I see there's two departments that have presented the process of implementing this system going forward. Now, I want to know, is seeing that this thing has been going on for a very long time, are there any turnaround times that we should expect for the full implementation of the system in these departments? Yeah, that's my second question. And the last question that I have, Chairperson, I want to know if the SIU has probably zoomed in trying to determine whether there is no correlation or any relationship between Oracle and NT department. I just want to know that as a matter of interest. And then, yeah, I think I'll pause there, Chairperson. Thank you very much.
Thank you very much. Start with the National Treasury.
Thank you, Honourable Chair, for this opportunity. Would you like us to respond to the questions as they arise?
Yes, please. As the individual raises the couple of questions.
Yeah.
Yeah.
No, thank you, Chair. Happy to do so. And I see Honourable Lees is not going to make me forget about what happened this morning. So I want to assure him that a full investigation is underway to determine how I ended up with the wrong time in my diary. Chair, I'm going to ask the Accountant General Shabir to come in on the specifics around the turnaround times, which Dpsa spoke to this morning, as well as the Oracle issue. Let me just talk to the issue of taking accountability, and I want to start off by just making a broader point. When we received the SIU report on Monday, we did write immediately, and I think Advocate you would have received it yesterday. We did write to Advocate Muti expressing, inquiring firstly about the status of the report, but then also expressing our initial reservations about certain elements of the report, and then requested an opportunity to engage with the SIU on its contents. It would be very unwise for us to respond to some of the details that was mentioned on a report that we received only 2 days ago. So what we are doing on our part, and it also relates to the honourable member's question, what we are doing on our part is we have engaged legal counsel. We are taking a look at the very detailed elements of it, including the allegations around the wastefulness of the contract, and we will respond to that after having received the appropriate advice publicly. But what we will also do is to engage the SIU directly on the areas that we quite clearly disagree with, and provide them hopefully with the evidence so that they can then consider that as they finalize their final report. Let me ask Shabir as well, or Dpsa, to just come in specifically around the issue of timelines, because we did spend a little bit of time on that slide, but it might be helpful just to give the honourable members a sense of exactly what those turnaround times are, and perhaps also to respond to the question around Oracle. Thank you, Chair.
Okay. Dpsa.
Yes, thank you, Honourable Chair. In terms of turnaround times for the full implementation, we are looking at a period of from start. We'll start with pilot. Our pilot will be completed for the entire system. The system will develop within a period of 9 months, and then it goes into a pilot implementation where we implemented at National Treasury and Dpsa for a period of 6 months to test it and ensure that it is indeed has set a basis for national rollout. And following that, we're ready for implementation at the other departments, noting that the system will be ready for implementation and the activities that need to take place at the different departments relate to data and data migration, as well as quality assurance and change management. There's an allocation of a period of 6 months to in-source or onboard a department onto the system, because there will not be
configuring the system. It will be ready. They just need to add the users and do a bit of configuration to align to their departments. But that exercise is scheduled to take place within 6 months, as the bulk of the work will be done in the pilot stages. So all in all, we're looking at a period of we're looking at a period of 22 months for departments to be onboarded. We indeed noting that we depend on capacity from implementers to ensure that there's this parallel implementations running across departments countrywide, but the system will be ready in a space of 9 months and piloted for a further 6 months. Thank you.
The Accountant General, you just to say anything? Okay, true. Satisfied. Okay. The Oracle.
Yes, thanks, Honorable Chair. I believe that question was for the SIU.
The guys are from Sita.
Thank you very much, Honorable Chair. I think first we welcome the presentation. Unfortunately, as Sita, we have not received the report from the SIU. But I think to answer your questions directly, the conclusions or the outcome slides are relatively very serious. So one, if SIU is declaring the procurement process irregular, invalid, and as well as we are blacklisting Oracle, that's a very serious discussion, which means then we can't continue an implementation with Oracle. I don't have the report. Maybe I need to start the chair. Sita has not been provided with the report, but I would make that statement openly to say Sita has never challenged SIU reports, and Sita openly works and assists the SIU. I can confirm that. I've reduced it into writing also when I was MD from January 2020. And some of the meetings they mentioned, I was there in my capacity as MD. So the plea then would be SIU must provide us with that report as quickly as possible. But the outcomes are relatively serious, and we are not sure and not aware of the engagements that SIU is having with Treasury. But if SIU is declaring the contract as irregular, that must then be cancelled. It bottom line means Sita cannot continue with Oracle. That's simple. So, and then Chair, I would prefer to leave it here purely because we have not been provided with the report. We have not continued through the report. And then Chair,
Mr. Chairman, sorry, may I come in, please? Chairman, we're into question sessions now, and are we getting into a discussion here?
Yes, don't worry. We have said initially, you are at liberty to look into the report, to deal with it in whatever way you think it satisfies your institution. But what is crucial for us, a system which has never worked, system which is not there, and which is as well so doubtful whether it will work. So you must satisfy us that you are not wasting money, public money, which you have already wasted, because there's nothing on the ground in terms of this system. So whatever you do, deal with it within that context. Satisfy taxpayers that at your hands, you are responsible for something that is going to be realized. Now you're talking about another period, which means period failure to another period, which you have outlined here as we're getting into cloud, and you have to assess whether cloud is within that 2013 business case as your responsibility in terms of such. So give us comfort that there is no wastage here. In your own words, you said you had to assess the doubtful nature of the cost factor getting into this kind of a project, which is going to continue with a test of unbearable costs, probably double of what you have seen now. It has been your own words. So your assessment has been there. You've been providing that kind of a leverage for us to understand. So the basis of discussion, what Honorable Yes is getting into, that give us comfort, give us time. We're going to ask those questions from yourselves. And any conclusive nature of what I'm going to do about the report, it's your own interest. You see, but coupled with issues, steps which we have dealt with, we have read it to yourselves, that there have been internal investigations, forensics, which present that doubtfulness. You see, matters that need the attention of those who are the holders of this kind of a project. You know, and those are the issues which are worrisome when we sit on this side. When you are challenging wastefulness of what has been done in terms of those payments, you see, give us time to ask questions, or we can answer those questions at the correct time. I think that's our appeal for now. Give us that sense of comfort. Your points might be valid, but valid as they are, talk to the SIU and then you deal with the report in a way you would want to deal with. SIU, there's a question on Oracle which has been asked. Can you respond from?
Thank you, Honorable Chair and Honorable Members. As the outcome of the investigation, we have not found any other kind of relationship except what the lead investigator has presented in terms of the interactions that pointed to lack of integrity in the process. And we did indicate that, you know, we've assessed the email correspondence that pointed to the lack of integrity in the process. We have not established any other specific nature of relationship between National Treasury and Oracle. Just to maybe clarify also, and I think it's really a legal concept. We have found that the procurement process was irregular, and therefore the contract should be subjected to legal scrutiny, adjudication, and be set aside. So we are, yes, on the way to ensure that the court adjudicates, or the special tribunal adjudicates, and they are the ones who will judicially declare the contract to be irregular and set it aside, right? So really, what happens in between? It's a matter of engagement, yes, but we have come to specific findings, which we are welcome to engage on as we then prepare on this aspect to go and present to the court or the special tribunal, and we can really engage Mr. Casey around, you know, either making the presentation firstly available to you, and of course probably taking you on board around the findings that we will be taking to court. And as we prepare the court papers, there are parties to the court papers, and we will determine in terms of who is the party to the litigation process. In many instances, ordinarily, SIU is the main applicant to the courts, because in terms of the law, we've got the judicial standing to make the application in our own right on the state. Now, the respondent would be either Oracle and the co-applicant, you know, ordinarily would be the state, the state institution, and in this regard, National Treasury, you know.
But depending on the outcome of the engagements, they could either be, co-applicants or respondent. But I'm really just, stating it now here that but with regard to the findings, we are here, and those findings have a measure of finality, and that's why we have started a process to court. Thank you very much.
Thank you, Advocate, for that. We are going to deal with a number of issues here, which might end up into your direction. But the level of engagement is in the report itself, which is you are at liberty to do so, and the party which is the holder of the report is the SIU. So you're coming together to your own commitment that you've been working together. You get closer as parties and look into what matters are somewhat raised there. You see. So let's leave at that point currently and allow members to ask their questions. Honorable Liz.
Thank you, Mr. Chairman. Yeah, I kind of have not quite had a Damascus Road experience, but sort of, because earlier this morning, Mr. Chairman, I was chatting to colleagues behind me here and saying, this IFMS matter, and I was talking in isiZulu, ngathi yazi selifile. That this matter really is a dead matter, but I've changed my mind. It's not quite dead. We need to kill it now. So, Mr. Chairman, the SIU report is very revealing, very revealing. And my concern really is now that on the one hand, we have National Treasury and Sita telling us of how they're going forward with this project. Not that they've put it on hold or anything. They're going forward, and then you have National SIU saying, well, actually, we're about to cancel this contract. So you've got a complete conflict here. And I understand that there are legal principles involved. I would hope that the respondent is not National Treasury, and that National Treasury is the applicant in this matter. Because I would hate to see the two of you going head to head in court. So that does concern me as well. So, Mr. Chairman, I don't know, as I said earlier, when the Deputy Minister asked the question, what role we should be playing here is pretty minimal. It's a role of seeking information and perhaps giving some sort of recommendation at the end of it, but that's going to be quite difficult. So, Mr. Chairman, my question, and I don't think it would be a fair question, my question was going to be to Sita National Treasury, after seeing the report, hearing the report, are you changing what you're telling us about what you're going to be doing next? Would you now say to SCOPA and Parliament, hang on, the picture's changed, we're going to have to put the brakes on here now? Or are you still going to forge on? I know that you haven't seen the report. You've only had it a few days, so it's probably an unfair question to ask. But that's the, I think, fairly urgent question to be dealt with here, because otherwise we'd be spending more money on something that will never come to fruition, or may never come to fruition. Never is... as my father used to say, never use the word never, because tomorrow never changes. So and perhaps the two parties can kind of respond in some way to that, but I'll leave it to them. Then, Mr. Chairman, to Sita, if you've got more than 100 people standing by to implement something that hasn't even started yet, what are those 100 people doing right now? I'm just visualizing an office that's full of people sitting there saying National Treasury or Oracle, get on with it. We're waiting to do some work. I hope I'm wrong. Genuinely hope I'm wrong. Mr. Chairman, the Advocate Matibi and I had a bit of a sparring match yesterday about names. And so I hope we don't have the same sparring match today. The circumstances are different. Can we have the names of the disciplinary referrals, the blacklisting, the criminal matters? I mean, I'm particularly interested in the previous DGs because I think it's well known that I have spent 14, I said yesterday 15, it's actually 14 years working with Finance and National Treasury. And I have had a huge amount of respect for the whole department, but also for the DGs of the past. And Duncan, I have for you too, even though you're new, but I have worked with you in the past. And so it's really disappointing that 2 previous DGs may be part of the 5 criminal referrals. And so he's looking glum. He's not looking happy. I don't know whether he's going to give me the names. And Mr. Chairman, then I'm sitting esiZulu senkhulile kodwa angakagugi. But yeah, and I'm quite savvy. I've got an iPhone and this, but to get my mind around this thing that we purchased. Where is it located? Is it, it was not going to be a cloud system. Where is it located? Is it on a mainframe in Tshwane, Pretoria? At the moment, where's our value? Is there anything that we can actually? I think there was one department using it. I'll leave that there. Okay, sorry, I'm acting like an ignoramus, and I probably am an ignoramus when it comes to these things. So, Mr. Chairman, thank you very much.
Thank you very much, Honourable.
Thank you very much, Honourable Chair. Now I can finish a direct answer to what I was explaining, Honourable Chair. Because the recommendations or the findings or conclusions by SIU simply mean we can't continue, which is what I was explaining, Honourable Chair, and I was stopped in the process. I can't shall I? So when that contract is declared as possible, I can't continue spend Sita money to assess cloud variant, to look at a 2-year implementation, to look at more cost to the state. So bottom line, with that conclusion, although I have not seen the report, I am quite sure as Sita directors will then say we can't approve continuing with even piloting implementation because we are now spending more costs that will still have to be recovered. But I'm saying so, Chair, knowing very well I have not received the report, as well as I am not sure who I am a client of National Treasury. I am also not sure who I'm their client, what's then the position of National Treasury. But looking at that, for Sita, it would then mean stop until you finalize that process so that you don't further spend more money into it, perhaps work in recovering that. But that would on a high level from where we're sitting, but we don't have the detail. In terms of the 100 people, the architects, the solutions and technical architects, purely because this has not been implemented yet, we've deployed them to work on all other solutions that we have for government, but simply I can't have people sitting and waiting. So they are then working on developing other solutions, whether you talk the e-services that we have on the eGov portal and any other work that we do, whether it's on criminal justice system. So we assign them to do work because I can't pay people that are sitting doing practically nothing. But we have skills that when this is implemented, I now need dedicated people to come in. Yes, they will be brought in. We've also signed what we call it a contracts with lots of private sector companies to say, as and when I need a resource, I will come and get a resource from you quicker if my advertising process will take long. But those people that he has on his team are working in developing solutions for other people so that we spend money on it. Where is this thing that has been implemented, Honorable Member? In Peter Maritzburg, in our data center in Maritzburg, there is a prototype of the solution which has been sitting there, which we are internally maintaining. So that's the only thing that exists now, which is then the prototype that we've had is been installed in our Maritzburg office, and some of his officials are looking at it now. So I think that's the direct answer, Honorable Chair, that I can give. We can continue having seen that, but I need the full report so that Sita can have an official discussion also with Treasury. We are their service provider at the end of the day. Thank you, Chair.
Thank you, Mr. Case, on that. Honorable, are you satisfied with the expenses? Okay.
Mr. Chairman, it's actually not. It's just a comment because the 100 people obviously are. I mean, I'm being facetious asking the question because I couldn't possibly imagine that you would let them do nothing. But the answer is raises a concern that I didn't raise, but I should have raised earlier. Because in the absence of the IFMS, other clients are developing other systems. And that may have its own impact on the implementation of IFMS. Am I right?
Thank you very much, Honorable Chair. So some of the solutions that we implement are not HR, finance, procurement. So we might implement other solutions that have nothing to do with that, but I use the skills. So I think the only similar things we'll talk to that might be the e-recruitment platform, but we minimize anything that talks IFMS, but I use the skills. So if you talk e-passport for Home Affairs, I use the same skills because what you have, the passports you get from banks, are things developed by Stima's team. So I use them to develop a lot of these other systems so that people get to do work and they become productive. Thank you, Chair.
No, I think that point is very crucial because you have appointed individuals for specific purpose. And through creativity, innovation, you take them somewhere. So we are forced to have a lot of army of individuals towards, and then Treasury comes and fight with the Auditor General on their, you see, wasteful and irregular expenditure. For what? When you have allowed people to get into things which they were not initially somewhere there. And all this, what we're discussing now, that you might be in this kind of a situation because of the intransigent in trying to listen and deal with matters which have been raised by the Auditor General in addressing the matters that you face. Following the Senior Counsel's advice, which you have driven the Auditor General to initially, 2018, with yourselves. So which advice do you want? You want advice which goes with your own intention. Now you want to go to the second Senior Counsel advice. So it's expenditure of money on things that you're advised on. You see, the SRD is saying, if you have taken the advice from Sita on the appointment of some services, you would have not been in this kind of a situation. So it looks like throughout the process you've been advised, but you choose your own way. You see, you lay your bed, sleep on it. So that's what is coming out now. You see, you get other institutions to do certain things. They get into those things, then you fly away. What do you expect? What do you expect? You put up a fight with the AG on something you have to know you are flying towards. So all these kinds of things, not that you are not advised, you see, you are advised. Now you're taking the step of a different format of the audit, real-time audit, which is a very good thing to do. so you can improve your accountability and the actual observance of these instances, which are going to take you closer to better way of doing things. Accountant General, thanks for your arrival. Thanks for your arrival. You see, it might be a better way of handling these kinds of things, getting the work together to find solutions on these matters. You see? You have your hand up, Honorable Lucas.
Thank you, Honorable Chair, and I want to thank the
Sorry.
Huh?
Honorable, this is asking.
I asked the unfair question, but I seem to think I might get a response if there isn't.
Sita responded. No, Sita responded. I thought that solid fine. Okay, DG, baptism by fire and welcome.
Thank you, Honorable Chair. Yes, I wouldn't expect any less. Chair, there were two parts to the question. I think the second one I had asked Shabir to speak to, because the honourable member also asked about, what does this system look like, and how can one intuitively describe it. I think a lady spoke about the different modules, but I think perhaps Shabir can also just talk about it in intuitive terms. In terms of the first question, what is the way forward? It is unfortunately an unfair question because it's only been 2 days, and frankly, even if it's been 5 days, it would probably still be too short a time, because what we need to do, which we started at 7:30 a.m. yesterday, is engage our legal counsel. And so that's what we did. We received the report on Monday, 7:30 yesterday. We engaged our legal counsel, and we are now in a process of talking to them about what this means. I think the overriding principle here is, as per the letter to Advocate Matibi, is that we intend to fully cooperate with the SIU and any other authorities that are investigating, but we have to ensure that we are guided by the correct legal advice, and that's what we're currently doing.
Thank you, Mr. Chairman. And I accept that. But I noticed that Advocate Matibi has chosen to escape and run away without responding.
Okay. Do you want a response from? Oh, okay. But we dealt with something yesterday. We dealt with something yesterday. The principle is that when we engage in the process, there's no fight into that process. You can't get into that risk of throwing names into these matters. And if need be, you can go and seek advice on that matter. So advocate. I'm not trying to be advocate, but the matter was raised yesterday, and we agreed that in principle we might disagree on it, but the fair, you see, reality is that you can't venture into throwing names when you are still deep into investigation, no determination, finality on such aspects. Yeah.
No, thank you, Honorable Chair. Yes, indeed, the principle is still the same, even in this investigation. We are really constrained, and until the processes are completed, people are charged and so on. All we can do, Honorable Chair, is really to ensure that the process moves quicker, so that people that is concluded quickly, so that people know where they stand, and then at that point we would know that who was charged, and so on. So I think that's the best we can do, so that the process is not delayed. Thank you.
Thanks, Advocate.
Thank you, Mr. Chairman. So it does answer my question, because it sounds like no one's been charged yet. The referrals have been done.
That's it. Yeah, Honorable Bucas.
Thank you, Chair. Chair, as I was saying, in acknowledging the reports of all the parties, and but especially in listening to the report of the SIU, I want to know, Chair, before we proceed with my questions, is this maybe a futile exercise, because you only received the report of the SIU on Monday, and your report was not based on what is contained in the report of the SIU. So maybe, Chair, maybe, Chair, we must give them time to go through that report and with the service provider, and then maybe we can give them time to come to us. Because if I look to the report of the SIU, as one of the officials was saying also, that it changed things now. So I just want to know from our side, is this not a futile exercise that we're engaging now in a report that is not based on the investigation on what is in the SIU report? Maybe you must answer me.
No. It's you. We are here to relate into the standing of the IFMS. There are a number of processes which are involved out there. We are agree with you on that. Now that we have received the report, it's fair to them to say, look into the report, reflect, and whatever needs some kind of bringing together in terms of your report and what the SIU is coming with, do it and come back to us. So you can make that kind of a way forward, if you may say, but without throwing away the seriousness of matters which have been raised there, taking note of those areas, and implore all parties involved that they should take note of such kind of issues which have been raised, and in getting into substantive nature of their own trail and track in dealing with this project, taking it forward. They must have a clear outlook of such. You see the extent of matters which have been raised. From us, we can't pretend as if we haven't received these reports, including the SIU report. It would be really futile if you take it that form. We received the report from National Treasury in terms of the steps they are taking, the report from Sita in terms of their own areas of advice, technical matters, and the areas that are reflected by Dpsa and what Advocate TV SIU report entails. And when we outlined in terms of the track of this, for example, the portfolio committee undertook a journey somewhat on the 29th of March to National Treasury, after they discovered that about 2 billion rand has been spent on something which does not exist. So they went there. They say when they speak about it, we got into offices, areas where there ought to be some infrastructure. It's empty. It's empty. It's empty. Nothing there. You see, so nothing is taking place. So they went there. You see themselves. So So we can't pretend as if there's no urgency in dealing with these matters, including what has been raised by the SIU. What is crucial as well is that Sita is saying that they've undertaken an assessment, which is a critical point of where you'd want to go on the cloud, you see. And through their own assessment, they had to determine that costs have been incurred already or not, does not exist. And then we are taking a journey towards rectification, getting into something else probably similar and so forth. So they had to get into the critical assessment of technicality on that process, and then they've given you the advice. And that advice, even on the cost factor, what needs to be done to relate into somewhat don't incur the multiple impact in as far as the cost levels are concerned. So there are a number of things in terms of depth of technical advice which has gone through into the elements of what you want to do currently. What I do appreciate from my side is that now you are saying, let's have real-time audit as we implement, which is going to ascertain that there are no trippings as we go along on what we want to implement, whether it's reduced, modified, or whatever direction it wants to be. But fairly, money has been spent. The project has stalled. Nothing on the ground, nothing in terms of the service to those who have committed to be party into that MOU. You see, so those kinds of things can be somewhat neglected, you know. So your fresh route that you want to take must then take along an added advantage that here is the SIU's report as an institutional driver of this project. Look into that report with an eye, which is saying, how can we escape these weaknesses and move forward? And I think that your question that goes directly into such. Here is an opportunity. We are given the report in terms of its own finality. Yes, it has reached some steps of finality, but you can engage with the report to understand it and to assist in terms of the progress and process going forward. Don't be emotional about it. There should be no emotions on it. In a substantive way, appreciate those kinds of things which want to correct, redirect, and look into how, in applying what you want to achieve, justice goes along with it. You know, where we're sitting, we're not in the investigation aspect, we're on the oversight aspect. So the detail of things would need to, you know, where I'm frowning at the DG, where I'm frowning at. You see, whether you are creating awareness to those who are in the application implementation of programs, because they undertake the routes which are going to realize irregularities. The Accountant General, those kinds of things we can't run away from. You know, if you say, I was in the process of realizing a sports field, and the sports field is not there, and you have spent money, that is irregular. You see, it's irregular. There's no truth and froze about it. A number of departments, here's the TG, could attest to it, maybe has been in other departments. Should your own experience. There might have been such kind of experiences. Why, if it's yourselves now, National Treasury, it can't be me. It should be them. Then you cry foul. You know, integrity of senior councils is at stake here because you want your own senior council. There's been advice provided by senior council previously. The age is prepared to go with you again on another senior council. It's on the same matter. What do you want? No. Fortunately, it's just a few days in the department. You might see it differently. It's a call on you to infuse a different way of dealing with these kinds of things. Assist the processes, get them engaged. You see, take them off the route they're taking. It's not helpful. We said so to the acting DG, Mr. Momo, sitting in the seat, that route is not the correct route. We're still saying so, it's not the correct route. It's only a bad example for those which you ought to guide as National Treasury out there. It's a bad example. Exemplary, at least, in dealing with these matters. Welcome to the Department of National Treasury. Welcome you. More than welcome. Colleagues, if there are any other questions, we must somewhat the lights are going to go off in the next 10 minutes.
Just maybe 2 or 3. Chair, you raised the issue of the dispute between the National Treasury and the HSA. I just want to know with this new senior counsel or the external legal resource, when was it referred to this? When was this matter referred? And which external legal company and what is the cost? And also the 8 million licenses that was purchased, but only you can only for one. Why this? Where's the others? Is it not yet rolled out? Then am I right to say that since the last scope meeting there is no progress on the the chair was referring to National Treasury as a guide, and I think, Chair, I will, in my responsibility as a public representative, and also in my responsibility as a SCOPA member who protect the public first, I must say, Chair, that I can't understand, and it's heartbroken to see the disregard of Treasury for policies of government. And if we read through the AG's report and also what is happening in the investigation of the SIU, it's not to respond to me. If you can respond, you can, but it's just heartbroken to listen that you as a pioneer for policies in the financial management of departments, this thing in Treasury. Then my last one is that Sita was saying that they did sign the MOU, but that there is a signatures outstanding, and that's why the MOU is not concluded. I assume it's the signature of Dpsa that you did not sign yet because reasons that you named here. Then, are you part of the steering committee, Dpsa and Sita? And how often is the meetings of the steering committee? Thank you, Chair.
Thank you very much, Honorable Pukas. Are there any comments on what Honorable Pukas was saying on the matters raised in the Dpsa? There's a question which goes directly to yourself on the MOU.
Thank you, Chair. Yes, ma'am, we are part of the steering committee, and I think it meets monthly. The steering committee meets monthly, and we have been meeting because we have been looking at the new procurement that Treasury is trying to do in relation to fast-tracking the implementation of IFMS. I do want, Chair, I think just taking a bite in the conversation that has taken place and the stance of Sita in the conversation as well, to say that I think it's going to be important, Treasury, that we meet as soon as possible as the steering committee to really take stock and see what's next, because we are suffering from a point of view of the services that we need to deploy in the public service. We don't have an e-recruitment system for the country for the public service. And Treasury issued an instruction that department will not procure separately because of the IFMS. So if you advertise a position for an admin assistant, you get applications, more than 2,000 applications that you have to go through manually. As departments, those departments that do not have systems, which is most of the departments in the public service. So whilst the processes of SIU and other investigations are continuing, I think we have to answer the question, how do we ensure that we bring in systems in the public service that are going to assist us to move from where we are, because we are very paper-based processes and there is no efficiencies in those processes. I'm making an example about e-recruitment system. We need a performance management system for the public service. We need an e-leave management system for the public service. The challenges that we have with management of leave in the departments also has to do with paper-based processes, and there's lots of implications from a financial point of view because leave is cost. So when leave is mismanaged in departments, when people take days, they are not recorded properly in systems and etc., and there's no monitoring mechanism or capability in place, then there's lots of money that the state loses through that. So those are just examples. So my appeal to my colleagues is that we have to answer these questions. How do we ensure that we roll out a system that's going to enable us to be able to fulfill what IFMS was meant to fulfill? Because we've been waiting for so many years and it's not moving forward. And now with the report of SIU and what Sita is saying, my biggest fear and worry is that we're going to be working on this for another 3 to 4 years and there'll be nothing tangible that we are doing to roll out this digitization of our program 1 in the public service. Thank you, Chair.
Thanks, DG, on that point. But the other question which she asked was, is there any reason that you are not signing?
She was giving the reasons most.
Yeah.
Chair, I have written to Treasury on this matter. I have explained what the challenge is of Dpsa. I cannot, as an accounting officer of the department, sign and commit to do certain functions that are in the MOU when I know that I do not have capability and resources to do those functions. And I do not have money from my budget to be able to hire the relevant resources to do those functions. So the conversations I've been having with Treasury, or at least the letter we wrote to Treasury, was to say, look at your PMO capability that you have, or if you have any further resources within the PMA, even if you were to appoint one project manager who's going to focus on the aspects that relates to the rollout by Dpsa, because we need technical expertise there, and we don't have those technical expertise. The colleagues who are babysitting the process have other roles and responsibilities that they need to take care of. They were not appointed for the sake of rolling out the IFMS. So that is the issue. From an accounting officer point of view, I have explained that I cannot sign an MOU when I don't know how I'm going to finance it in order to roll it out. I am not able to do that. So I am still awaiting for that engagement, or at least for a response from Treasury in respect to those areas. And I understand that DG is new, so we haven't even had time to meet because I have a list of things that I would like to raise with him, but he landed on a hotspot even on the first day that he started the job. I hope that he will settle with all these problems and then we can also have an opportunity. Thank you.
Just a quick follow-up on this. When was the last steering committee meeting? Because I got the impression the departments are using this platform to speak to each other. So
Okay.
I just want to know, when was the last steering committee meeting?
Okay, Treasury.
So, Chair, I'll respond to all the other questions that were directed to us as well. I'll ask Dikeledi to come in on the issue of the last steering committee meeting, and Shabir on the question the honourable member asked around the referral of the matter to senior counsel. But let me just speak briefly to some of the other questions. I think what we tried to put forward in our presentation, Chair, was that in our view, there has been progress since the last meeting, but I do think what the members here are pointing to is the fact that that progress in and of itself is perhaps not sufficient. What then further sort of muddies the waters, as it were, is of course that our presentation then didn't speak to the report of the SIU because we couldn't take that into account. But there have been, and there is a specific slide in the presentation that speaks to some of the specific matters that have been addressed, including some progress that we've made with Oracle since the last meeting. So we could cover that ground again. In terms of the role of the Treasury, I think as an institution that is meant to be exemplary in this matters, I think that's something that we certainly do take seriously. And in light of what was presented by the SIU and to the DG of DPSA's point, the reflections that we have to undergo are not necessarily only related to the specifics around the IFMS, but it's also about the broader implications that it has for departments like DPSA in terms of how further delays on this impact their ability to do their work. So that is definitely something that will be part of our reflections. It's not just about reflecting on the SIU report, but it's reflecting on the broader ecosystem and what these delays mean for that. These delays mean for that. Finally, Chair, on the issue of the procurement problems that were highlighted in the SIU report, I think 2 points to make there. The one is that we have, since the time of IFMS, we have made some significant efforts in addressing some of the shortcomings in our own internal procurement processes. And we did, Chair, as recently as last year, initiate a process to again review our internal supply chain management processes to ensure that it is up to standard. And perhaps one of the things we should do at a future meeting is just brief the meeting on the efforts that we've undertaken in that regard, because a lot of what the SIU focuses on in their report are historical procurement challenges within the department. And I think it might be good for us to come back and just speak directly to those and what we've done to address that. Thank you. And then over to Shabir and Dikeledi on the other matters, Chair.
Thank you, Duncan. Honourable Bierkus, your question around the senior counsel, if you just maybe allow me to provide some context as well to that before providing you a direct response. As the Office of the Accountant General as well, we do see a number of disputes between auditees and auditor, and we often get involved to really come in and resolve such matters. This is a very similar matter, and we were hoping that the current dispute resolution mechanism of the Auditor General would have resolved this